Your Honours, it is our respectful submission that there is one issue really for the court, which is it contrary to public policy for this court to grant leave to the bank to enforce the award? I have, as is my practice, prepared a speaking note for the benefit of the court and my learned friends on the other side, and I hope your Honours have it. I propose to stick very closely to the note. Your Honours, I think it's important to start with my paragraph 4, where we identify 4 points which we say are common ground between the parties. And the first is that there is no prior legislative approval was required for the government to validly enter into the loan note. And I provide a citation where that can be picked up. The question of enforcement does not arise until and unless leave to enforce is granted. The reference for that is at page 967 of the record.
9 what?
967, paragraph 70 of the submissions of my learned friends. Thirdly, legislative approval is required for payment of the award as a judgment from the Consolidated Revenue Fund. And fourthly, the obligation to lay a supplementary appropriations bill before Parliament would arise if leave is granted. Your Honours, it is our submission that taking these 4 points of commonality between the parties, the real question is if the court accepts these points, namely that there was no need for prior legislative approval, 2, the question of enforcement and the question of laying an appropriation bill only arises after a leave is granted to enforce, and it is accepted that the prior legislative approval is required for monies to come out of the Consolidated Revenue Fund to meet a judgment. We are then thrown to the sole issue: is this court's grant of leave contrary to public policy?